What next? That's the question that lots of employers are asking this morning. It's a lot of questions I've gotten via phone calls and emails and other messages. What next in light of the Fifth Circuit's decision staying the OSHA vaccine or test emergency temporary standard on the basis of what the Fifth Circuit called grave constitutional and statutory concerns with that standard. Here's my answer. What I am telling people in light of the Fifth Circuit's stay is really to stay the course. I think employers must act as if this ETS is still in effect and that the January 4 deadline for employees to be fully vaccinated or start weekly testing is a real and hard and actual deadline. Here's why. First and foremost, we don't know if the Fifth Circuit's stay operates nationally or if it's limited to the states specifically within that circuit, Texas, Louisiana, and Mississippi. Secondly, and I think maybe more importantly, the Fifth Circuit may not even have the final word on the legality of this emergency temporary standard. There have been to date 5 lawsuits filed challenging the legality of that standard. You have the one in the Fifth Circuit. You have another one in the Eighth Circuit, another one in the 11th Circuit, and 2 in the Sixth Circuit. And so we have 5 competing lawsuits. And under the federal rules that govern multi-circuit litigation, those cases now must be consolidated and heard by one circuit court to be chosen by a lottery. Another court could just as easily step in and rule contrarily to the Fifth Circuit, which is traditionally the most conservative of all the circuit courts. The Fifth Circuit could rule on its preliminary injunction this week, which it said it would, and in the meantime, another circuit could come in and undo that ruling, could vacate it, could vacate the stay. Any host of things that can happen once a court, if it's a court other than the Fifth Circuit, is chosen via this lottery. And finally, if the ETS is ultimately upheld, employers who assumed either its application was stayed or that it would be struck down are really going to be behind the 8 ball from a compliance standpoint, operating under a timeline that will be virtually impossible to meet. Therefore, I think unless and until the Supreme Court says otherwise, employers should assume that this ETS is in effect and should act accordingly by getting their policy in place, by collecting vaccination records from employees, by mandating the vaccines, by that January 4, 2022 deadline, or assuming that employees will then have that January 4 deadline to then test in lieu of the vaccine mandate. I think ultimately, at the end of the day, I think this OSHA standard may end up it's going to make a huge difference, but even if it's found to be illegal, I think it's going to serve its purpose because businesses, because of this tight 60-day window we're operating under, must operate on the assumption that this vaccine mandate is going to go into effect. In order for employees to be fully vaccinated by 1/4/2022, those that are unvaccinated now are going to have to start getting shots. They can get their first shot and then their second shot either 21 or 28 days later, depending if they get Pfizer or Moderna. And so really the time to start getting shots in arms is going to be in the coming weeks to meet that 1/4/22 deadline. So even if this is ultimately struck down by the courts, or by the Supreme Court, I think it's going to serve its purpose by getting many, many more people vaccinated as a result. And separately from that, this Fifth Circuit stay doesn't impact federal contractor or subcontractor vaccine mandate, which still goes into effect 1/4/22 and doesn't affect the vaccination requirement for healthcare workers working in facilities that receive Medicare or Medicaid that similarly goes into effect at the same time. So bottom line is employers need to act accordingly as if this OSHA emergency temporary standard is going to take effect as planned and scheduled and start getting their policies and procedures in place ASAP. Okay, employers, that's your update for today. Separately from this legal update, I'm curious if you like this format, if you like me talking to you via video as opposed to me typing out my thoughts and you reading it. If you do, I'd love to keep doing updates this way, not every day, maybe not even every week, but every now and again. Drop me a comment, shoot me a note in the comments below, send me an email, drop me a tweet or a message on LinkedIn or something to let me know if you like getting video updates like this as opposed to the written updates here on the blog. That's it. Everyone have a great day. Cheers.